I want to thank you all for coming and being with us here today, and I'll let you start because there's a lot of material to cover, and
Yes.
go for it.
We have ways to go here. We're going to get through a lot of information for you. We'll try to do it from a practical point of view and give you the substance of the cases, and you will find in the materials, you'll also find that we have the case sites as well. Now, why don't we just launch right in, and we're going to start in the area of copyright, which is also always a very fertile ground for litigation. And Milt, we've got a couple of cases that you were going to start us off with in the copyright infringement area.
Sure. We have Price versus Fox Entertainment Group. This is the dodgeball case. If any of you have kids, and I have 4 sons, you get to see this movie a lot. This is the Ben Stiller movie involving an underdog sports team, dodgeball team that enters a national tournament. The screenwriters in this case brought a copyright infringement action against Fox, alleging that essentially their manuscript was stolen. The court in this case granted summary judgment in favor of the plaintiffs, the screenwriters. What the court found was both works are superficial, fast-moving comedies, spoofing underdog sports films. Each work told the story of a group of misfits led by a main character who forms an underdog dodgeball team pitted against a stronger rival team of bullies. In each work, the underdog team decided to enter the national dodgeball tournament that awarded prize money, which the team needed to save a business in distress. And in addition, the court found that several characters that appear in both the defendant's version of the film or in the earlier drafts that the defendants did share the names and certain characteristics of the characters in the plaintiff's work. The court also found that because the defendants, there was an issue, it seemed that the defendants had access to the plaintiff's manuscript as a result of knowing someone at the William Morris Agency. They also factored that into their analysis, and they found in favor of the plaintiffs. That's the dodgeball case.
And then we have another one here that's, and these are one of these cases where, you know, courts will often say, and we also talk about summary judgment, historically was not supposed to be easy to get in copyright infringement cases, but we have one, we see it more and more in copyright infringement cases, summary judgment without a trial, and we have one of those right here in the Slice of Pie Productions case.
Yeah, this is the second case, and again, if you have 4 sons, you get to see this movie a lot. This is probably why I volunteered for these particular 2 cases. Anyway, the Slice of Pie is the White Chicks film with the Wayans brothers, who, if anyone remembers In Living Color, you're very familiar with the Wayans brothers. In this case, the court, it was brought in the District of Connecticut, it was decided in 2007, and the court granted summary judgment on behalf of the defendants. In this case, it was the Wayans. The screenwriters who brought the action had a screenplay about an African-American FBI agent who disguised himself as a white Italian-American to infiltrate the mafia. Anyone who's familiar with the White Chicks film knows that the Wayans brothers, who are African-American, disguised themselves as 2 very socialite and very well-to-do white women who were in their, I think, early 20s, and were hanging out in the Hamptons to crack a ring out there. And I forget exactly what the crime that was going on was, but the court found that based on the concept, the theme, the characters, the sequence, pace, and the setting of each film, and they found no substantial similarities. In addition, there was evidence that came out during discovery that the Wayans had been contacted by the Slice of Pie Productions individuals on several times and had turned them down over and over again, saying, no, this is not the kind of angle we want to take. And obviously, the White Chicks film was different. So this is an instance where summary judgment was granted on behalf of the defendants in a copyright infringement matter. Okay.
Now, another key issue in this case, and also one that the defendants won on, is the claim of breach of implied contract. Because here, as Milt was saying, there was no promise, there was no bilateral expectation of compensation. So the plaintiff's claim for implied in fact contract did not prevail. But I just want to quickly update you on a major case in that area out of California, Grasso v. Miramax Films. And that is one where in 2004, the Ninth Circuit said that the implied in fact contract claim was not preempted by federal copyright law because it had an extra element to it. And that was remanded back to the state trial court. Well, there, just recently, the California Court of Appeal, it looks like near the end of that case, has said that there was no implied in fact contract in that case, because of the fact pattern where you have somebody who's basically sending out, reading Writer's Market and sending out a screenplay. This was based on, I wrote a screenplay and you did my movie, you did your movie based on my screenplay. Let me just quickly give you the site for that so you'll have it. This is, again, implied in fact contract dismissed, as in the Slice of Pie Productions case. This is Grosso, Grosso, v. Miramax Film Corps. It's B193872. Well, now we're going to go over into the, as we still continue to move along with copyright, we're going right into the internet area. Well, let's take a look at internet issues, copyright,
Fair use.
and fair use.
Can everybody hear me? I don't know if I'm supposed to get this closer.
Go right ahead.
Okay, let me try and get it closer. I'm too short for this. All right, don't read anything into the subject matter here because I did not volunteer for the next two cases. I was assigned. Perfect 10 is the plaintiff in our next case. This comes out of the United States District Court of Appeals for the Ninth Circuit. Perfect 10 owns, markets, and sells copyrighted images of nude models. And Perfect 10 also operates a subscription website where subscribers pay a monthly fee to view Perfect 10's nude images. And they also licensed an entity to sell and distribute reduced-size images for download on use on cell phones. Perfect 10 claimed that Google and Amazon impermissibly facilitated access to infringing images of Perfect 10's photographs by displaying thumbnail versions of the images on their search engine website and by linking to third-party websites that displayed infringing full-sized images. The Ninth Circuit affirmed in part and reversed in part. The district court had issued a preliminary injunction for some of the activities that Google was engaged in. The court held that in seeking preliminary injunctive relief, Perfect 10 had the burden of showing not only likelihood of success on the merits, but also, once raised as a defense, a likelihood that it could overcome defenses raised by the non-moving parties, and the fair use defense was raised. On the issue of direct infringement, the Ninth Circuit agreed with the district court that Perfect 10 was likely to succeed in its claim that Google's thumbnails constituted direct infringement of the right of display, but said that Perfect 10 was unlikely to succeed in overcoming Perfect 10's fair use defense because the use was highly transformative and provided a social benefit. The court found that Perfect 10 had failed to introduce evidence that Google's thumbnails harmed the market for full-size images, and the fact that Google made a significant derived a significant commercial benefit from its use of the thumbnails did not sway the court against a finding of fair use. The Ninth Circuit also agreed that Perfect 10 was unlikely to succeed in its claim that Google's inline linking to full-size infringing images on other people's websites constituted an infringing display or distribution of Perfect 10's images, and it had the same finding as to Amazon. On the issue of secondary liability for infringement, the Ninth Circuit reversed the district court's holding that Perfect 10 was unlikely to prevail on its contributory infringement claim and remanded the issue for the district court to consider whether Google had knowledge that infringing Perfect 10 images were available using its search engine and could take simple measures to prevent further damage to Perfect 10's copyrighted works and failed to take such steps. The same analysis had to be taken for Amazon as well, so there was a remand on that issue as to Amazon. And then finally, the Ninth Circuit affirmed the district court's holding that Perfect 10 was unlikely to prevail on its vicarious infringement claim because Google and Amazon lack the practical ability to police the infringing activities of third-party websites. And because they have no control, the court did not consider the extent to which Google may have received a direct financial benefit. That's
Now,
Perfect 10.
Now, this is interesting because that's a
Sloth through fair use.
Ninth Circuit case, and on the issue of that, the court finds that the use of the thumbnail-size images is a fair use because we've had, we can compare that to the Second Circuit ruling on Bill Graham Archives from a year or so ago, v. Dorling Kindersley. That's where there was a book called The Grateful Dead, The Illustrated Trip, and the defendant, writer and publisher had used posters of Grateful Dead concerts owned by Bill Graham Archives, but put them in thumbnail-size images in the book. This was not on the web, but in the book, but it's the same kind of idea. There seems to be, and in that case, thumbnail-size images, a chronological history, and juxtaposing the images created a transformative use, and it was fair use. So here we have the Second Circuit in the Bill Graham case and the Ninth Circuit on a similar issue in the Perfect 10.
Both finding fair use.
Yes, both finding fair use.
So the next case is way more fun. Burnett versus 20th Century Fox Film Corp. In that case, the show The Family Guy, which routinely lampoons celebrities, aired an episode entitled Peterotica, where the family patriarch, Peter Griffin, that's my neighbor's name, enters a porno shop with his friends and remarks that the shop is cleaner than he expected. One of his friends explains that Carol Burnett works there as a part-time janitor. And the show then switches to a less than 5-second scene of an animated figure that resembles the charwoman character from the Carol Burnett show, who's mopping the floor next to blow-up dolls, XXX movies, and a curtained room with a sign above it that says video booths. As the charwoman mops, a slightly altered version of the theme song from the Carol Burnett show is playing, and Carol Burnett was not amused. She filed a lawsuit asserting copyright infringement, a Lanham Act violation, trademark dilution, and common law right of publicity claims. The very sympathetic court, after considering all of the fair use factors, nonetheless held that the work was clearly a parody and as such transformative, that while the nature of the copyrighted work was clearly expressive, that was not much help because parodies almost invariably copy publicly known expressive works, that the show did not take any more of the charwoman's character than was necessary to place the image in the mind of the viewers, and that the demand for the original copyrighted work would not be supplanted by the use. So the court found that there was a fair use and no copyright infringement. On the Lanham Act claim, the court said that there was absolutely no likelihood that viewers would be confused into thinking that the use of the charwoman character was actually authorized by Carol Burnett. And the court said that the more outrageous and offensive the parody, the less likely any confusion will result. And then went on to say how offensive the parody was. Because the parodied work was non-commercial speech, it was not subject to a trademark dilution claim. And on the state law privacy claims, the court then declined to exercise supplemental jurisdiction and basically said if you want to pursue that, go to state court. So that's Burnett.
Let's get this right, though. What we have here in this case is a comedian filing suit against a comedy show. I just want to get that out there. But it's another example of transformative use at work.
Yes.
It's a strong part of the fair use analysis, obviously.
I mean, maybe it's possible that as you age, your sense of humor declines, diminishes.
Pardon me?
Am I still, I'm up again?
And now we have one we're going to go to the photography area,
Okay.
right, for a copyright case.
And yet another fair use case. This one is Blanche v. Coons. Second Circuit decided this case. It was an appeal from an order of summary judgment in favor of Jeff Koons. The facts. The plaintiff, Andrea Blanche, is a fashion photographer. She published a photograph of a woman's legs adorned with Gucci sandals and bronze nail polish resting on a man's knee while the two were in an airplane cabin. I think this was in Allure magazine. And it was a photograph supplementing an article.
Just what did Carol Burnett think about that? I just wondering. That description you gave, Sandy.
I don't know. So Blanche testified that in creating her photograph, which she called Silk Sandals, the creative director of Allure suggested the model, the sandals, and the nail polish to be used. And Blanche's contributions were her control over the camera, the film, the lighting, the composition of the photographs, and that it was her idea to use an airplane interior as a backdrop and to place the female model's feet on the male model's lap, explaining that she wanted to show some sort of erotic sense and get more sexuality to the photographs. I'm sensing a theme in all three cases here. Christine, did you set me up?
You're doing great. It fits you so well.
You know me well enough. They don't. Okay. So, Defendant Jeff Koons created a collage painting in which he copied but altered the appearance of part of the copyrighted photograph by Andrea Blanche. In creating a series of paintings called the Easy Fun Ethereal Paintings, Koons culled images from various advertisements, scanned them into a computer, digitally superimposed the scanned images against backgrounds of pastoral landscapes, and then printed color images on there and painted them. Koons testified that he was inspired to create his work called Niagara because he wanted to comment on the ways in which some of our most basic appetites for food, play, sex are mediated by popular images. And he testified, by recontextualizing these fragments, as I do, I try to compel the viewer to break out of the conventional way of experiencing a particular appetite as mediated by mass media. Koons included in his painting only the legs and feet of Blanche's photograph, and not the background of the airplane cabin or the man's lap on which the legs rested. He inverted the orientation of the legs, added a heel to one of the feet, that was probably hard, and modified the photograph's coloring. Blanche, not surprisingly, sued for copyright infringement, and the court commented that the copyright law must address the inevitable tension between property rights it establishes in creative works and the ability of authors, artists, and the rest of us to express them, or ourselves, by reference to the words of others, the works of others. The court held that Koons's appropriation of Blanche's photograph was a fair use. The court found that Koons's purposes in using Blanche's image were sharply different from Blanche's goals in creating it. Koons said that he was using the image as fodder for his commentary on the social and aesthetic consequences of mass media, and that his objective was not to repackage silk sandals, but to employ in the creation of new information, new aesthetics, new insights, and understandings. The use was therefore transformative. Because the new work was substantially transformative, the significance of other factors, such as commercialism, were of less significance. Moreover, notwithstanding that artists are sometimes paid, the court held that the public exhibition of art is considered to have value that benefits the public interest. The amount of the photograph taken was reasonable in light of Koons's purpose, and none of Blanche's contributions were included in the painting. By Blanche's own admission, there was no market effect on the original works, and that all supported the finding of fair use.
Well, let me see if I just kind of summarize your cases quickly.
Everything's fair.
We've got, it's all these transformative uses. We have this couple on the airplane. Carol Burnett comes by down the aisle with a mop, and it gets published in Perfect 10.
And it all has something to do
What
with
happens?
sex, but I'm not sure what.
But it's all a transformative use. That's the key issue here. Well, now let's take a look also in the United Kingdom and UK. We have a lot of copyright litigation, and Nick, you're an expert in that area, and you've handled many important cases. Give us an update, please, on some of the key copyright infringement cases
Thank
from
you,
the United
Stan.
Kingdom.
Well, the first case was an absolute cause célèbre. It was concerning breach of copyright of the Da Vinci Code. A book had been written in 1982 by the claimants called The Holy Blood and Holy Grail, which I'm sure everybody here has read. And it's all about the Cathars and the Albigensian Crusades, the early Christian church, the Priory of Sarum behind the Knights Templar, and all that sort of good stuff. And Da Vinci Code was published in 2003, and they claimed that a substantial part of Da Vinci Code had been taken from the prior work, The Holy Blood and Holy Grail. Particularly the central theme, they said, had been copied. It came for trial before someone called Mr. Justice Peter Smith, who is, if you didn't know him beforehand, you'd certainly realize after his judgment that he's probably stark staring bonkers. He took a mere 3 weeks to deliver his 70-page judgment, and in the course of it, he himself included a code, something about the HMS Dreadnought, which was a ship of the First World War fighting. And the Court of Appeal said, remarking about his judgment, that the judgment is not easy to read or understand. It might have been preferable for him to have allowed more time for the preparation and checking and revision of the judgment, which is judicial code for saying your chances of promotion to the Court of Appeal are absolutely zero. Despite that damning indictment of the style of his judgment, they actually agreed with his conclusions that there had been no substantial copying. And the case is really concerned with what rights are there for historians, or in this case, quasi-historians, because the Holy Blood and the Holy Grail is a book of historical conjecture. It's not actually historical fact. What rights do they have to the fruits of their research? And it was really summed up by Lord Justice Mummery, who is the intellectual property judge of the Court of Appeal. And he said the position is that individual elements of the central themes distilled from the Holy Blood and the Holy Grail are not sufficiently developed in character to constitute a substantial part of the Holy Blood and the Holy Grail. In the words of the judge, they are too generalized to be a substantial part of the Holy Blood and Holy Grail. They are an assortment of items of historical fact and information, virtual history, events, incidents, theories, arguments, and propositions. They do not contain detailed similarities of language or architectural similarities in the detailed treatment or development of the collection or arrangements of incidents, situations, characters, and narrative, such as normally found in cases in infringement of literary or dramatic copyright. The 11 aspects of the central theme in Da Vinci Code are differently expressed, collected, selected, arranged, and narrated. So they said that the literary copyright that exists in the Holy Blood and Holy Grail, by reason of the skill, labor expended by the claimants in the original composition and production of it, and the original manner or form of expression, the results of their research. But original expression does not include only the language in which the work is composed, but also the original selection, arrangement, and compilation of the raw research material. It does not, however, extend to clothing information, facts, ideas, theories, and themes with exclusive property rights, so as to enable the claimants to monopolize the historical research or knowledge and prevent the legitimate use of historical and biographical material, theories propounded, general arguments deployed, or general hypotheses suggested, or general themes written about. The big point about this is there was no actual textual copying, so they had a really uphill struggle to win that case at all. And what we think the case is really all about was the authors of the Holy Blood and Holy Grail wishing to generate publicity for their book on the back of the Da Vinci Code. And the real issue that us litigation lawyers want to know is whether the costs which they had to pay the defendants when they lost the case actually were greater or lesser than the additional royalties they gained from bringing the case in the first place.
This is interesting because we've had, as you talk about this, Nick, this case, we've just had in the last few days a ruling on the Da Vinci Code, a copyright infringement case here in the U.S., the U.S. District Court for the District of Massachusetts. There was a lawsuit, the plaintiff's book was called The Vatican Boys. And what's important here and interesting is that the plaintiff proceeded, part of this case was about something called a theory called structural or thematic similarity, not the word substantial similarity. And the judge said, wait a minute, I'm not even going to get structural or thematic similarity. That's awfully general when you get down to it. The plaintiff hasn't showed me a case dealing with those concepts, and I haven't found one. So that case ended up being where the plaintiff lost. So we've had 2 wins here for Dan Brown.
Sure. Okay, now the next case should be accompanied by a little bit of music. Thank you very much indeed. Hands up anybody in the audience who doesn't know what that song is. One of the most famous songs ever recorded, A Whiter Shade of Pale. Okay, that's fine. It is actually more fun than listening to me, but that came out in May 1967, and it is said that John Lennon was driving in his car when he heard it coming over the airwaves, and he pulled into a siding to listen to it, and then he rang up Paul McCartney, not from his mobile phone, I can assure you, and said, gosh, why can't we write songs like that? It became a completely cult song. That version by Procol Harum sold over 6 million copies, and it has been covered over 770 times by other pop groups. The song copyright was credited to Gary Brooker, who is the guy who plays the piano on the track you just heard and who sings, and the lyrics were credited and written by someone called Keith Reed, and nothing turns on the lyrics. Matthew Fisher is the organ player, and he was not credited with the creation. The judge did, however, find, not surprisingly, that the organ solo is a distinctive and significant contribution to the overall composition and was the product of skill and labor on the person who created it, which was probably, frankly, J.S. Bach.